Hello, my name is Jodie Bettis. I am a Grand Union Scholar at the Open University in the UK, studying for a PhD in Geography. I'm researching how the law affects the environment and how the environment impacts on law, and I'm interested in the mass destruction of ecosystems. This subject takes me into the interdisciplinary realm of legal geographies, and this paper presentation explores how law can better protect ecosystems from severe destruction and deterioration through the introduction of ecocide and rights of nature legal provisions, and specifically how the UK has an opportunity to adopt a hybrid approach to its post-Brexit environmental lawmaking. I begin with a brief explanation of the legal theory within which my work is framed, and introduce how the juridical relationship between constitutional and criminal law is transposable into an eco-legal context. Next, the meaning and use of the terms ecocide and rights of nature in both common and legal language are summarised before looking at the socio-legal geographical context within which these terms are codified. This section 3 of my presentation, is very much a work in progress, and I would greatly appreciate your feedback and suggestions, which you can leave on the Reimagining Sustainability discussion board. Finally, in the time remaining, I focus on the development of ecological law in the UK by presenting specific provisions in the recently enacted Environment Act, and finish with a look towards future possibilities for the codification of ecosystem protection in post-Brexit law creation. American jurist Wesley Newcomb Hofeld noted in his 1913 study of the fundamental legal conceptions used in judicial reasoning that, I quote, "Rights are routinely used by lawyers and judges to refer to at least 4 legal concepts, including the rights that give rise to the duty on another, privileges, powers, and immunities." End quote. For the purposes of this paper, I'd like to draw your attention to the rights which impose or infer duties on others. These rights and duties are written in a country's constitution, or in the case of the UK, which has no singular constitutional document within the body of its national constitutional laws. An act which infringes upon a legally recognised or codified right, or transgresses from upholding a codified duty, can be made illegal and thus a criminal offence. A clear example of this is the human right to life. An individual's right to life, to exist, imposes a duty on others not to extinguish that life. If this duty is transgressed, a criminal act has been committed, and this is denoted by the suffix "cide" in the recognised crimes of femicide, homicide, infanticide, etc. This Hofeldian logic can be transposed into environmental law to protect nature when the locus of rights is shifted to the ecosystem itself. Infringing on nature's right to life transgresses a duty of care towards the environment, an act which Scottish barrister Polly Higgins argues in 2010 should be made an international crime, a crime that can be codified with the same "cide" suffix, the crime of ecocide. Therefore, to achieve the normative outcome of ecosystem protection in law, legislators can recognise the constitutional rights of nature or the crime of ecocide, or both, depending on the political and legislative structures within the juridical territory. The word ecocide entered the English lexicon over 50 years ago and was first used in print in 1969 in a local paper in Ohio in the US. Since then, according to Microsoft Academic, the word ecocide had been used in 599 publications, indicated by the blue bars on the graph, and cited over 5,500 times, indicated by the dotted line, to December 2021. The red arrows on the graph show key dates in the trajectory of increasing usage in digitized print. First coined in the Southeast Asian context, the term was originally used to describe the effects of biochemical products used to destroy forest and farmland during the Vietnam War between 1954 and 75 and the Malayan Emergency between 1948 and 1960. You can see from the graph that the concept begins to gain traction again around the time of the UN Conference on Environment and Development, or Rio Summit, in 1992, but it isn't until the publication of Polly Higgins's book on the subject called Eradicating Ecocide and the advent of the climate change rallies around the world that the term is popularised in both academic and everyday language. The word ecocide is now used in common parlance to describe the widespread destruction of living systems in a specific area or any action capable of destroying an ecosystem. It is synonymized in the Longman Dictionary of Contemporary English with the two-word term ecological genocide and was selected as Word of the Year in 2018 by the editors of the online Cambridge Dictionary. But is the term ecocide now as ubiquitous in law as it appears to be in environmental discourse? The short answer is no. Just 10 countries, none with English as the national language, recognise ecocide as a crime. In 1996, 5 years after the end of the Soviet Union and 4 years after Murray Feshbach published his comprehensive study on ecocide in the USSR, Russia became the first country in the world to criminalise ecocide. A domino effect of similar, almost identical clauses in the criminal codes of ex-Soviet states began, ending in 2003 with Armenia. But can you spot the odd country out? Yes, Vietnam. Although never a Soviet state, as a socialist republic, it received economic and military assistance from the Soviet Union and continues to be a political and military ally of Russia. Internationally, there is no law against ecocide. A proposal to include ecocide in a draft list of judicable crimes of the International Criminal Court was rejected in 1973, as was a proposal to include it in the Rome Statute in 1995. In 2021, an independent panel of international law experts, led by a barrister of Her Majesty the Queen's Counsel, Philippe Sands, QC, published a proposed definition of the crime of ecocide for the ICC, but to date, no country has taken steps to introduce such an amendment. The second legal provision under consideration in this paper is the rights of nature. This legal and jurisprudential theory, also referred to in the literature as earth jurisprudence, describes inherent rights associated with ecosystems and species similar to the concept of fundamental human rights. Unlike the word ecocide, rights of nature is a three-word term and as such is not defined in a dictionary. It is often conflated in search engines and citation software with human rights to nature or natural rights in law, and so this has necessitated the manual collation of data to construct a similar graph showing mentions in the literature over time. The graph on this slide was prepared by environmental attorney and senior counsel at the Leonardo DiCaprio Foundation, Linda Sheehan. It is reproduced here with her kind permission and shows the pattern of publication data from 1995 to 2019. You can see the trajectory of increasing usage takes a similar path to that of the term ecocide. What's not included on this graph, however, was that the concept, like ecocide, was being explored as early as 1972 in English-speaking countries, most notably by the then unknown lecturer in property law at the University of Southern California, Christopher Stone, who mooted legal personhood for natural objects in his seminal paper, Should Trees Have Standing? As noted by the chair of this conference, Professor David Humphreys, in his 2015 paper, Know Your Rights, and I quote, "Recognition of nature's rights holds out the possibility of an alternative approach to environmental management and politics, as well as to a fundamentally redefined relationship between nature and society." End quote. This redefinition can be said to have begun in 2008 with the introduction of a new constitution for the Republic of Ecuador. Chapter 7 of the Constitution details the rights that nature has within the territory and the duty of care the state and its people have to safeguarding nature. Article 71 highlights 4 key areas that are common to all codified examples of these constitutional rights: the rights of nature to exist, persist, maintain and regenerate, within interconnected integral systems. The concept of evolutionary processes gives these rights a temporal context. Legal protection is given to ecological systems in perpetuity and not just to atomized elements or taxonomically classified species and habitats. To date, there have been 20 countries that have recognised rights of nature in subnational, i.e. local laws, beginning with Tamaqua Borough in Pennsylvania, the US, in 2006, with the most recent proposal put forward in Donegal County Council in Ireland in December last year. On inspection, however, the rights of nature motion proposed by Sinn Féin councillor Albert Doherty was not, I quote, a legal construct, but rather a statement of intent which, again I quote, recognises that rights of nature can help catalyse an innovative rethinking about how to create regenerative, not extractive economies, while also making human and other living communities safer, stronger and more resilient, end quote. Rights of nature at this time do not wield any legal authority in the Republic of Ireland. There are, however, 3 countries that recognise rights of nature either in the Constitution or in national law, thereby giving ecosystems within the sovereign territory fundamental rights similar in wording to the Ecuadorian Article 71 of 2008. Bolivia enacted the Law of the Rights of Mother Earth in 2010, and Uganda enacted the 2019 National Environment Act, Part 1, Section 4, on rights of nature. Like Ecocide provisions, there is no recognition of rights of nature in international law. In 2009, the President of the plurinational state of Bolivia proposed to the UN General Assembly that the 22nd of April be recognised as International Mother Earth Day. This was accepted, and a year later at the World People's Conference in Cochabamba, a Universal Declaration of the Rights of Mother Earth was promoted by Bolivia and adopted by many civil society groups. To date, there is no international court, environmental or otherwise, to legally recognise infringements upon such rights or criminal breaches of duties related to rights of nature. In summary, protection for ecosystems at the national level has been legally recognised by a total of 13 countries, first with Ecocide provisions from 1996 to 2003, and then with rights of nature provisions between 2008 and 2019. This map I prepared from open source data available on the UN Harmony with Nature site. It shows the 13 countries and 20 subnational regions mentioned in the paper thus far. The areas in red recognise ecocide as a crime, the bulk of which are in the former Soviet bloc, plus Vietnam below, and the green areas recognise rights of nature. The dark green areas are where ecosystems have protection across the entire territory, whereas the light green areas indicate countries that recognise rights of nature in one or more subnational locations within the territory, primarily rivers and lands venerated by indigenous peoples. And this is where I am calling for your input. It is clear from this graphic that, although normatively connected, these 2 legislative approaches to ecosystem protection remain legally distinct. No country has codified both concepts concurrently. I'm currently working on understanding the socio-legal reasons for this global distribution of eco-legal approaches by exploring patterns in land ownership and political approaches to land use planning. For example, are current or former centrally planned socialist countries more likely to recognise ecocide as a crime than neoliberal economies? Does who owns the land have a bearing on how the ecosystems upon it are protected? Do ex-colonial or imperialist countries favour protecting ecosystems using constitutional or criminal law? So many questions and avenues of inquiry. Please leave your feedback and ideas for investigation on the Reimagining Sustainability discussion board. Thank you in advance for this. So, on to the UK. The light green shading on this map is the result of 2 council areas within the United Kingdom of Great Britain and Northern Ireland, that of Derry City and Strabane, and Fermanagh and Omagh, both recognising the rights of nature across a total of 1,131 square miles of Northern Ireland in 2021. It is beyond the scope of this paper to give a full history of the rights and duties and legal personhood for natural objects in the UK. Briefly, prior to 2021, rights of ecosystems to exist, persist, maintain and regenerate were not codified in domestic law, and ecocide was not recognised as a crime. There are, however, over 200 instances of duties in UK environmental law. Building on his 1972 seminal paper and using a Hofeldian conception of legal rights as co-relatives of legal duties, Professor Christopher Stone, in his 2010 essay, Does the Climate Have Standing?, uses the example of the US Endangered Species Act of 1973 to note that affirmative duties in environmental law infer rights upon a scheduled natural object. His point is equally true of the EU Habitats and Birds Directives and subsequent UK species and habitats laws. The first example of which can be found in the Game Act of 1831, which prohibits the taking of named species outside of licence. The 1949 National Parks Act was the first to legislate designating land as nature reserves. And by 1981, the Wildlife and Countryside Act had codified a duty on the state to safeguard natural objects through the scheduling of species, habitats and specific sites under threat from damage or destruction. With the UK leaving the European Union came the opportunity to reform environmental protection. Was the chance to introduce rights of nature and ecocide seized? Again, the short answer is no. The 2021 Environment Act did introduce additional duties on both public and private sector bodies in relation to enhancing biodiversity and reducing pollution in UK air and rivers. There were no provisions to recognise ecosystems in law, no enactment of the locus of rights in nature, and no recognition of ecocide as a crime, but not for the want of trying. I was an advisor to the former leader of the Green Party, Baroness Bennett, during the passage of the bill through the House of Lords. The Green Party introduced an amendment to define ecocide and provide the UK government with support to propose an amendment of the Rome Statute. I met with the Minister of State for the Environment, Lord Goldsmith, and provided briefings to peers on domestic ecocide provisions, which were debated at length. But in the end, the government was not minded to accept the additional clauses, and the window of opportunity was closed. So what is the future for ecocide and rights of nature law in the UK? There remains at least two drivers that may push the UK government to codify these concepts. One is the international obligation to recognise ecocide as a crime. The other is to harmonise rights of nature provisions across the kingdom. If or when the campaign to amend the Rome Statute is successful, signatories to the treaty would be required by international law to transpose the ecosystem protections into their domestic legislation. A total of 130 countries would then recognise ecocide as a crime, 123 of which could then take a case to the ICC for adjudication. The UK would be one of them. Another way of ensuring better legal protection for ecosystems across the UK would be a harmonisation of local bylaws and devolved regulations, as more and more sites and systems are expected to have their rights recognised in England, Scotland, Wales and Northern Ireland. Similar to the bottom-up process of harmonisation of national laws across the European Union, standardisation of a rights-based approach to ecosystem protection in law could see the four UK administrations working together on a UK bill that would recognise rights of nature across the entire kingdom. It is possible, perhaps even desirable, to couple ecocide and rights of nature into a single bill. The Green Party has stated its intention to enact such a law, and there are currently proposals by supporters of the abandoned ecocide amendments to begin the process of putting forward a private member's bill in the Lords. This hybrid approach would connect the criminal and the constitutional conditions required to protect ecosystems in law, and would provide two routes to the same normative outcome, that of better protection for ecosystems. That just leaves me to say thank you, gracias, for watching. These slides are available for download from the Common Ground microsite, and please do leave your questions or any comments or feedback on the Reimagining Sustainability discussion board, and I'll do my very best to respond to you during the conference. Thank you very much.